Perhaps, the one thing that should be considered most of all is that the current Idle No More movement is not merely limited to an environmentalist agenda concerned with proposed changes through Bill C-45 that indirectly affect Aboriginals and non-Aboriginal Canadians. Although there is concern for these environmental changes, which are serious matters in themselves. But considering these valid points about proposed changes through Bill C-45 concerning the environment, these proposed changes would effectively end the federal authority for protecting more than 600 bodies of water in Canada, and would be default responsibility to provinces. In this case, the checks and balances that were offered by the federal government would be gone. No more federal oversight, and the provinces are default custodians of the bodies of water in Canada. Less regulations for new business and at what cost. However, this should be the least of the worries Aboriginals should be concerned with. For example, the federal government is also proposing sweeping changes to the Indian Act, and some of these changes are very serious changes for Aboriginals. Currently, the proposed changes to said act are concerned with reservation lands that are already established and could be expropriated by the federal government's proposed changes to the Indian Act. The current allocated reservation lands that are occupied by Indians could be arbitrarily taken from aforementioned occupants at the government's leisure through what would become legitimate changes to the problematic Indian Act. In fact, the United Nations addressed the conditions faced by Aboriginal Canadians on reservations, but the Government of Canada did not want to hear about the human rights violations Canada was accused of. Canada, a first world nation allowing atrocities to happen within said country, and are condemned by the United Nations for social injustices faced by Aboriginal Canadians. In retrospect, it always seems easiest to lay blame, fault on the ones in that current state of deplorable conditions, at least for the Government of Canada. This ridiculous behavior would be like blaming the Jews for the Holocaust and saying, "You had it coming, it's all your fault." This is absurd and completely ridiculous beyond belief. No reasonable person would blindly believe the Jews brought the Holocaust upon themselves in Nazi-occupied Europe. Then, why can the naysayers try and blame the Indians for their current state of socio-economic conditions? The answer is simple. The average Canadian who is against the Idle No More movement is ignorant and does not understand, or does not want to understand, the greater political and historical significance of the state of affairs affecting Indians today. And, if this was not enough, in addition to the government's blind eye to the UN's concerns, the federal government wishes to expropriate current designated Indian lands through some sort of quasi-judicial amendment to the Indian Act. It seems easy to consider the federal government's change as allowing for the seizure of Indians' lands, for the government's benefit, is a bigger concern than the environmentalist agenda of the Idle No More movement. Environmental issues are fine, but where will the Indians be displaced to? Rather, relocated to if their current reservations are taken from the said Indians. Although the motives of the Idle No More movement are sincere, at least, in the sense they mean well and are bringing some issues to light, these issues are severely limited and fail to see the even greater significance of allowing the federal government to expropriate Indian lands. But, underneath these lands are gold mines of mineral deposits, natural resources, oil and gas, and the Indian problem is currently in the way of the economic expansionist policy of the federal government. However, there may be some hope left in the governing institutions. There is still the Supreme Court of Canada. The SCC could strike down the Harper government's current economic expansionist policy as unconstitutional, due to infringing upon guarantees within the Charter of Rights and Freedoms. The Supreme Court of Canada has ultimate authority, and is thankfully free from political coercion by the executive government, the Prime Minister, members of Parliament and cabinet ministers. This is the one good thing Canada has going for it, the autonomous Supreme Court of Canada. The SCC is free from external political coercion and is charged with the mandate of doing what is in the best interest of the Constitution, and not the government or citizenry. In summation, there is serious cause for concern considering the ramifications for the occupants of reservations within Canada, and the government knows the strategic, economic value of the vast majority of occupied reserve lands, and the government wants these lands. Besides, who cares about the Indians, right? Screw them. They lack the coordination, structure, education, financing, and there is so much political infighting amongst the Indians, they will never be able to coordinate an effective course of action to combat the Harper government, and the federal government knows this and is using this to its advantage.